Hi, my name is Dianne Bailey. I'm an attorney with Robinson Bradshaw. I am thrilled that you have taken the plunge to greater good. The Lee Institute is a tremendous resource for Charlotte nonprofits and well beyond our community, and you have the privilege of benefiting from their wealth of wisdom. So how grateful am I to be part of this series? I'm here today to talk with you about board governance for nonprofits, and I will tell you, I practice what I preach. My practice as a lawyer, where I lead the nonprofit organizations and foundations practice group at Robinson Bradshaw, is dedicated to the representation of nonprofits here locally, but also across the United States. I speak and teach and preach the gospel of how boards can propel nonprofits to achieve their mission. I also spend a lot of my personal life volunteering for nonprofits. I raise money, I plan and attend events, I advocate, I serve as an ambassador. I also have served on a number of nonprofit boards, more than I prefer to count, and I've chaired 6 boards in the last 10 years. So I come with war stories, and I hope a little bit of credibility. So without further ado, let's get started. So we know, based on what I'll tell you today, that you will give a lot of your time, a lot of your energy, a lot of your money to nonprofits when you serve on the board of directors. But what will you gain in return? Plenty. The first, of course, is personal satisfaction. My hope is that you align your personal passion with the nonprofit on which board you serve, such that you will find great satisfaction from that commitment of energy. Business development. Now, that is not why we join a nonprofit board, but particularly in Charlotte, the business community has a long tradition of civic engagement. So on your left and on your right at board and committee meetings, you will be networking and building relationships with other business leaders. So certainly expanding your business development opportunities. And network expansion. Some of my best friends in Charlotte are people that I've gotten to know through intensive, committed nonprofit board service. And of course, skill enhancement or extension. If I'm being honest, I think most of the time when I get the call to serve on the board of directors for a nonprofit, it's because they're anxious to have a lawyer with expertise in representing nonprofits sitting at their table. But I have used my experience serving on nonprofit boards to expand my knowledge and expertise in other areas. I do provide them with the legal insights, but I also have learned a ton about marketing, about advocacy, and other important skills gained solely through my service on nonprofit boards. And I hope you will have a lot of fun. So I've got five to-dos for nonprofit directors. This is your role as a director in a nutshell. Number 1, employ, encourage, and evaluate the CEO. Later on in the deck, we're going to talk a little bit more specifically about that very special relationship between the board and the CEO. But just know that that is your number 1 job as a board of directors. The second is providing a strategic vision for the organization. You are unlikely to be the subject matter expert for the organization on whose board you serve, but it's your job to ask the hard questions and to be a strategic advisor to the organization and be accountable for the strategic vision that the board ultimately will adopt and validate. The numbers. Everybody on the board is required to do the numbers. You'll be charged with approving annual budgets and also special capital budget plans, and also reviewing periodic reports. Monthly, quarterly, depends on the organization, but you will be charged with understanding the finances of the organization. Developing financial and other resources. Let's talk first about financial resources. When you agree to join the board of directors, you will write a check, a personal check. If your company is making a contribution, that is fabulous. Unless it is the company for which you are the sole shareholder, that is not a replacement for your personal check. We'll talk a little bit more later about how you might evaluate that commitment before you join the board of directors. Other resources, I think about this as utilizing your sphere of influence for the benefit of the organization. I hope you've got contacts with your local government, maybe state and federal as well. Oftentimes, particularly in human service, the lever is substantially moved by governmental programs and reimbursements. So being an advocate to the government can be very importantly aligned with achieving the mission of your nonprofit. Managing risk. Wow. As the lawyer, I'm very concerned about risk management. There's some high-level compliance issues about which you'll need to be aware, but know that that risk management is closely aligned with managing the reputation of the organization. What do I mean by that? If you're an organization that depends substantially, and in some cases exclusively, on contributed income, if you have a headline that is damaging to your organization, it can implode your business strategy because that contributed income can dry up very quickly. So managing reputational risk is critically important for the board. Now, just like I have 5 do's, I have 5 don'ts. Do not do these things. And I hope you'll notice that they're a corollary of your do's. So hopefully they'll reinforce what you actually should be doing as a nonprofit director. The first relates to the CEO. Your job is to, let's review, employ, encourage, and evaluate your CEO. Your job is not to micromanage your CEO. You need to hire somebody who is capable of fulfilling that role and support and encourage him or her in doing so, not micromanaging them in how to do it. Be a respectful boss. In addition, you also need to be sure that you do not try to manage the team. I love the org chart for a nonprofit that has on the top of the org chart the board of directors with a straight line down to the CEO, and then the rest of the team fans out. It helps you remember that your job is to manage the CEO. It's the CEO's job to manage his or her team. Second, remember your vision needs to be strategic, generative, creative to move the mission forward for the organization. Don't get bogged down in the tactics. That's the CEO's job and the job for the team. Now, you may have a role in implementing the tactics, but don't micromanage how those tactics are put into place. Now, the worst thing you can do, the only thing I think worse than getting too down in the minutia is being silent. If you are sitting in board meetings and you are being only reported to and your voice is not being heard, raise your hand and make sure that your voice matters. Third, do not misunderstand, or worse, ignore the financials. Now, I'm a lawyer, not a CPA, so I had to do some work to get on top of the financial reports, the 990, the audit, how to read them, how to understand them, to develop that baseline of financial literacy for nonprofits. If I can do it, you can too. Greater Good's providing you with some technical training, and there's other technical training available to you through the North Carolina Center for Nonprofits and some other resources. So I encourage you to avail yourself of them. Now, we know we're going to write a check. So when you write your personal check, do it with enthusiasm. I have heard commentators say that when you serve on a board of directors, the check you write to that organization should be one of your top 3 checks. Now, there's some organizations that may not move off your list from year to year, but make sure that you are contributing enthusiastically to your organization. And the last, of course, is no being asleep at the wheel. You've got to come to meetings, we'll talk about it with our fiduciary duties, participate fully in the life of the organization. Fiduciary duties, that is a loaded term that the lawyers like to use. So I'm going to explain to you how it applies when you are sitting at the table for the board of directors. There are 2 duties under North Carolina law. The first is the duty of care, and the second is the duty of loyalty. They are undergirded by good faith. you must approach each of these with good faith to the organization. The duty of care, I will not belabor this point because you know it when you see it. If you are exercising due care, you are, as I mentioned, coming to meetings, prepared, having read the packet, you're participating in committee meetings, you're asking good and insightful questions. And if you're having trouble discerning what's happening at the board table, you're going to ask some questions outside the boardroom. I love organizations that match a new board member with an experienced board mentor. So you can talk about the agenda before and, more importantly, debrief what happened after. Loyalty is a little bit more nuanced. I won't spend a lot of time now talking about conflicts of interest because they pop up later in the presentation. I'll flag it for you as a subpart to the duty of loyalty. The two other parts are the duty of obedience and the confidentiality requirement. The duty of obedience is a little less intuitive. What that means is that you, as a director, are obligated to follow the governing documents of the organization. So, the articles of incorporation, the bylaws, the other policies and procedures. Now, to state the obvious, in order to discharge your duty of obedience, you first must have a copy of those documents. Hopefully, when you join the board, you receive some training, and so they give you access to those documents, either in a notebook or by virtue of access to an online portal, but I trust that you'll then do the next thing, which is read them. A lot of times these documents are written in old-fashioned legalese. Hopefully the documents for your organization have been modernized. If the legalese is impenetrable, I hope you'll take it upon yourself to ask the follow-up questions so you can better understand the documents so you're equipped to follow them and comply with your duty of obedience. Confidentiality. A little complicated in nonprofits because in general, we want people to sing the story of the nonprofit organization anywhere and everywhere the directors find themselves. Where we need to be particularly cautious about the duty of confidentiality is with sensitive personnel matters and also donors that are either being solicited, so the gifts have not yet been finalized and publicized, or certainly donors that prefer anonymity. So employees and donors are areas where we're going to be particularly sensitive about this duty of confidentiality. All right, hot topics in governance and compliance. Hold on tight. This is exciting stuff here. First, board composition. The size of the board. Everybody wants to know what is the perfect size for my nonprofit board. And as the lawyers like to say, it depends. If your board is for an organization that is new or an organization that is in period of transition, you generally will favor a smaller board, 5 to 7, max of 9, because that group can be small and nimble. A small board also benefits from what we know from the organizational management research, which says that groups of people greater than 8 or 10 have a trust threshold that declines rapidly with the addition of new members to the group. So that small board for an organization that is in a period of rapid change, either because it's new or in transition, really benefits from having that small group where folks can trust each other. More mature organizations need and certainly can sustain larger boards of directors to get the overlapping skill sets and overlapping spheres of influence that they will need to raise the funds and to provide the other technical support that they'll need to really continue to move that mature organization forward. Independence on the board. I think about this in two different ways. One is you want to make sure that your directors are independent from each other. You don't want too many people from the same family, you don't want too many people from the same company, just to make sure you've got diversity of opinions and perspectives represented on the board. The other aspect to independence that is critically important is remember our org chart. If the board is here and the CEO is here, you want to be sure that your CEO is not a voting member of your board. think about the inherent conflict of interest that is embedded there. If you are your own boss, CEO, voting member of the board, it creates many opportunities for friction and challenges. So factor that in when you're thinking about independence on the board of directors. Term limits. Term limits are key. We need to keep new people coming on the board for fresh ideas and perspective. Typically, we think of individual terms of being between 2 and 3 years that then would be renewable for 2 or 3 times. So in aggregate, you would generally see the maximum amount of time someone would serve on a board of directors being between 6 and 9 years. And then you would impose a mandatory sabbatical of at least a year. I have served successfully with other board members who have come back after their sabbatical to serve again, but that resting period is very important for the organization, and whether they know it or not, for the person serving on the board. So term limits are really, really key. I won't spend too long talking about voting and voting requirements, other than to flag an issue that is commonly breached. There are pitfalls associated with e-voting. When we can't get a meeting together or something pops up in between meetings, often organizations will want to circulate a resolution by email and ask people to reply. I won't bore you with all of the details around this, other than to say, unless your bylaws give you permission to do that, you're not permitted to do so under state law. And if you choose to vote by email, state law requires that the response be unanimously favorable. So if you've got someone who's in Tahiti that can't reply to the email in a timely basis, that absent person could hold up the organization's ability to move forward. The better response, use your executive committee with disclosure strategically, or hold a telephone conference call meeting, which is a meeting in person under state law, so you don't have to have unanimity in response. Technical, but important. The role of board committees. I've already referenced executive committees. Executive committees can be very, very useful in tending to sensitive, timely, really urgent matters for the organization. Now, executive committees generally are composed of your officers for the board. So your chair, your vice chair, your secretary, treasurer, maybe your past chair or your incoming chair as well. Now, these groups should not do the business of the board in between board meetings regularly. Why do I say that? If a small group like the executive committee is really taking hold of the strategic vision of the organization and then reporting that vision out to the full board, is the full board really fulfilling the fiduciary duties held by all of the directors? So executive committees have a role, but it's much more limited than many organizations utilize at this point. So be mindful. The full board has fiduciary duties which may not be delegated to an executive committee or any other subsection of the board. The board-CEO relationship. This is where all the magic happens. If you have a board that is committed to support, encourage, nurture the CEO, that organization is the organization that has rocket fuel. On the contrary, if you have an organization where the board is either micromanaging or not supportive of the CEO, or worse, not engaged to really utilize their power and their influences for the benefit of the organization through the support of the CEO, your organization will flounder. So work hard at developing a very healthy relationship between the board and the CEO. Now, that said, we remember that the board is the fiduciary group and the holder of the accountability for the strategic mission of the organization. So it's important that the board maintain a culture that is its own, separate from the CEO. That is why executive session at every board meeting is really, in my view, very important. Usually that happens at the end of the meeting. Typically it's bifurcated. So the first half of executive session, the CEO would be present, and then in the second half, the CEO would also be excused, and the board would have time just itself to talk through any issues and ask any questions that they might not otherwise feel comfortable airing. The board must review on an annual basis the CEO as any other boss would review a direct report. It's really important that you get your goals set ahead of time, that there's documentation and great lines of communication between the board and the CEO in the context of those annual reviews. The board is responsible for the compensation established for the CEO. We know that nonprofit executive compensation is an area of significant scrutiny, both by the Internal Revenue Service and by the media. The Form 990 that I referred to earlier, and that I know it's been covered in another session for Greater Good, reports out the CEO's compensation very clearly. And as you know, the 990 is subject to public disclosure, both because it's on file with the guidestar.org database, and also because you must, as an organization, provide 3 of the most current 990s to anybody who asks. So know that the CEO's compensation must be fair and reasonable as determined by IRS regulations and as approved by the board. So critically important to that board-CEO relationship. The board chair has a very, very, very special role with the nonprofit. It is an incredibly powerful role if utilized properly. The board chair may not act independently from the board. The board chair's authority derives solely from the board. But the board chair is typically the person who represents the board in relationships with the CEO and more broadly. The board chair sets the agenda for the meetings and calls the meetings in most instances. So very, very, very powerful role and important role for the organization. Policies and procedures. So often, organizations look to the bylaws as the proxy for corporate governance for nonprofits. How often my phone rings and the beginning of the call, it is clear that they want some help with their governance, and the end of the call they ask, could you review our bylaws? And the answer inevitably is, well, of course we can review your bylaws, but first we need to review your Articles of Incorporation. The Articles of Incorporation that is the document that creates the organization under state law. That document also is subject to public disclosure, and it's online with the Secretary of State. When you look at the documents and the hierarchy, the Articles of Incorporation are at the pinnacle. If there were inconsistent language in the bylaws and the articles, for example, the Articles of Incorporation would control in that instance. The bylaws are the internal document that sets the parameters for how the board will operate. This document is not subject to public disclosure, other than it's attached to your initial application for tax-exempt status with the IRS. If you make changes to the bylaws after that time, you don't file them with any governmental entity, and they are generally private to the organization. There are exceptions to that, of course. But they are your rules of the game about how the nonprofit board will operate, and it is a very, very important document. The other key policy that every nonprofit, regardless of size, really must have is a conflict of interest policy. The conflict of interest policy that I prefer is one that tracks the IRS rules regulating financial transactions between a nonprofit and its insiders. Now, the term insiders is my term. That's not a term that you'll find in the Internal Revenue Code. They use the term disqualified persons. I'll spare you that technicality for the rest of this session and use the term insider instead. That refers to key employees, officers, directors, founders, substantial contributors, their family members, organizations they control. So know that that's a pretty expansive group. Anytime money is being paid from a nonprofit to those insiders, there is considerable scrutiny around that transaction to make sure it is fair and reasonable to the organization. So every organization, regardless of size, needs at least 3 corporate governance documents: articles, bylaws, and a conflict of interest policy. On the slide, you will see a laundry list of other policies and procedures that are commonly adopted by nonprofit organizations. The other 2 I'll flag for you because if you are a full 990 filer, so not a 990N, not a 990EZ, but a full 990, the IRS will ask you, do you have a document retention policy? Do you have a whistleblower policy? And typically you'd like to check that box, yes. So while it's not required under law that you have these policies, you likely would want to adopt them if you're a 990 filer, if for no other reason, to be able to respond favorably to the IRS. Moving right along to my favorite topic, federal tax law. Hang with me. We've just got 4 main areas to cover. First, 990s. We've already talked about the importance of the Form 990 as a document in the public domain. The IRS is looking at this document, the media is looking at this document, and importantly, donors are looking at this document. The Form 990 should be reviewed by a subsection of the board and certainly provided in full content to the entire board before it's filed on an annual basis. Now, why do I emphasize annual filings? If you fail as a nonprofit, and you cannot believe it's true, but I'm here to tell you it is, to file the Form 990 for 3 years in a row, your tax-exempt status will be revoked by operation of law. There will be no warning, there will be no investigation, there will be no opportunity for apology. Your organization will simply vanish from the IRS's list of approved tax-exempt entities and moved to the list of entities whose tax-exempt status has been revoked. You may make application with a user fee to have your status restored, retroactively even in some instances, but this is a headache you don't need. File your 990 on time every year. And as a reminder, it is subject to public disclosure. It takes about 6 months for it to be uploaded to guidestarbot.org, but it will appear there. In addition, anybody who asks must receive the 3 most recently filed Form 990s just because they called. So factor that in. Lobbying limitations. I've already told you that there is power in advocacy for almost every nonprofit. I encourage you to talk with your legislative officials about issues that matter for your organization. If you do so, you must keep in mind the limits under federal tax law, however. There are 2 tests. The default test is one that's a little squishy, facts and circumstances test that says that only an insubstantial part of your activities may be dedicated to lobbying. The alternate test is much more mechanical, but requires some record keeping and some disclosures. You can make that election by filing the Form 501H, but that is a much safer place to be if your advocacy and lobbying agenda is very active. Now, as of the date that we're recording this session, the Johnson Amendment is alive and well. There is a lot of conversation nationally about whether that will continue to be true. If there is a change, we will alert you to it. But today, nonprofits are not permitted to engage in political activity. So, making contributions, advocating for or against the election of particular political candidates. I cannot overstate this point. Very important that nonprofits be nonpartisan as it relates to particular candidates. Now, intermediate sanctions, excess benefit transactions, these are fancy IRS tax terms for the conflict of interest transactions we've already discussed. So those transactions where money flows from the nonprofit to its insiders. Now, insiders are a broadly defined group, so just be careful when money from the nonprofit goes in the form of compensation to your key employees, under business contracts, or otherwise to your directors, officers, founders, substantial contributors, also to their family members. So a lot of sensitivity here. It should be covered in great detail in your conflict of interest policy. Now, that does not mean that you may not engage in financial transactions, nonprofit, to the insiders. A prohibition on that is not required, and that prohibition generally would not be in the best interest of the organization. If people serve on your board, they generally do so because they're passionate about the mission of the organization. They are much more likely to give you a good deal than to take advantage of the nonprofit. So make sure that you follow those procedures outlined in your policy. It should require disclosure of the potential transaction, a requirement that you rely on comparability data. So salary surveys, competing bids, other written offers to determine that you're paying fair market value or less. The deal is better for the organization. And then you must thoroughly document that in the minutes. This is an area of intense scrutiny by the IRS. So you need to have on audit proof in the form of a record of an approval of that conflict of interest transaction to show them if they ever were to call and ask questions. So consider that. Now, two more areas. These are also important, and then we'll move on to something that ought to matter to you a lot, risk management for you personally. But before we get there, hang with me. Solicitation licensing. This is the permission from the state of North Carolina to a nonprofit organization to ask for charitable contributions. This is a consumer protection effort by the state of North Carolina and the 39 other states throughout the U.S. that have similar protocols. You must ask to be licensed. You will be granted a license that, again, is subject to annual renewal, another filing requirement that you must consider each year for your organization. There are certain disclosures that must be made in connection with obtaining and renewing the license, and I cannot understate the importance of this. Like the IRS, the North Carolina Secretary of State has considerable authority in terms of enforcement actions related to solicitations without a license. They also have the ability to assess and collect material fines for noncompliance. So make sure that this is part of your annual overall compliance strategy. Audits and internal controls. Not every nonprofit is required to have an annual audit. We generally recommend that organizations that have revenue of between $250,000 or $350,000, somewhere in that threshold, commit to an annual audit by a qualified CPA. There are organizations that have lower budgets that may also be required to have an audit, generally in connection with state or other governmental funding. But for other organizations where an audit is voluntary because it's not required by a funder and certainly not required by law, that's the threshold, quarter to $300,000, $350,000, where you'd really want to seriously consider committing. Now, if you do not have an audit, you might consider another form of CPA review or a compilation. So other strategies to get some additional accountability and oversight to your financial records without investing the time and certainly bearing the burden of the expense of a full-blown audit every year. Now, if you read the audit carefully, you will understand that that is not a blessing of your books. So if you are concerned, and I'm here to tell you you ought to be concerned about the integrity of your financial statements and concerned about the risk of mismanagement or diversion of assets in the form of embezzlement or some other fraud, then you might consider hiring somebody to come and periodically conducting an internal controls investigation. They can provide great strategies for your organization in terms of segregation of duties and other things even very, very, very small nonprofits can do to ensure that the assets of the organization are used for the charitable purposes. So factor that in. Now, I have spent more minutes than were allocated to my presentation on the responsibilities of directors. But I feel it's important that we also talk about your rights as directors. And there are several really important rights that are given to directors of nonprofits under state law. So I'm going to talk about them briefly now. The first is access to information. As a nonprofit director, you have the right to ask for copies of minutes from meetings, financial records, including from periods before you served on the board. So you need information to discharge your fiduciary duties, and the organization has an obligation to provide that information to you upon request. Notice of meetings. If you happen to be the naysayer on the board, it is not permissible for them just not to invite you to the meetings. Every director has the right to receive notice of every meeting. Special meetings. I talked before about the power of the board chair in terms of crafting the agenda and calling meetings of the board. If the board chair is not calling the meetings and having the agenda that you believe is appropriate, take a look at your bylaws and certainly take a look at state law, because there are opportunities for groups of directors to come together to compel the organization to call a meeting if so warranted. Keep that in mind. Quorum. If you don't have at least half plus one of your board, typically, look at your bylaws, but typically that's a threshold, present, the board cannot act as a board. Now, state law, I will tell you this, but I'm not condoning this, and North Carolina permits a quorum as low as 30%. Don't do that. Have at least a requirement that half of your board be present before decisions can be made for the organization. And why do I say that? If you have only 30% of your board attending a meeting, query, do you have the right directors for the organization? Record of dissent. If you were to get to the place where you believe the board was coalescing around an action item for the organization that you believe to be fundamentally ill-advised, and your voice of reason is not carrying the day, if you get to that very, very difficult and unusual place, you have the right as a director to require that the secretary to the board record your dissent by name. Do that, particularly if it is an area where there might be exposure to some personal risk. Make sure that you have at least that first line of defense as having dissented to the organization's action that you believe to be ill-advised. Now, if you get to the point where you've had to record your dissent, even one time, I caution you to think about whether it's appropriate to resign from the board. And how you resign and whether you resign is a conversation for another day, but you have the right to say that you prefer to return your fiduciary duties to the organization and step back and away as a voting member of the board of directors. Personal liability. Now, we have already established that you have many benefits to gain from your service on a board of directors. However, those benefits should not be at the price of exposure to personal financial liability associated with your service. Now, there is a very deliberate reason why I put this slide at the end of the presentation, particularly knowing that this is a webinar. Not sure that you've been paying attention the entire time, and certainly did not want to give you permission, because the news on this slide is so good, to leave me early. But in North Carolina, there are many features of law and many affirmative steps that a nonprofit can take to provide very strong protections for their individual directors. The first line of defense is that you're a corporate entity. Remember those articles of incorporation that we've talked about that are on file with the Secretary of State. That is a very powerful first line of defense for personal shield of liability. The business judgment rule. The North Carolina courts have historically been quite generous with nonprofit boards of directors. If you document in your minutes that you relied on information, that you deliberated as a group, and you arrived at an informed considered decision that you believed at the time to be in the best interests of the organization. Capture that language, put it in your minutes. Of course, make sure it's true. Then the courts generally will be quite forgiving if, fast forward, that decision turns out to be ill-advised. So that business judgment rule really does provide considerable protection in the eyes of the courts in North Carolina. Limitation of liability. Wow, this one is amazing. It's not unique to North Carolina, but not as many states as you would hope have built this into their statute. What we have in North Carolina, it says that if you put in your articles of incorporation, now you must affirmatively elect to this. It's not on the pre-printed form from the Secretary of State, so go and look at your articles online for an organization that you serve on the board and confirm that this language is here. But what it says is that directors for the nonprofit will not be held liable for breaches of fiduciary duty. This is huge. Now, we could have a long conversation about why you would or wouldn't want to relieve a director for a breach of their fiduciary duty. But I'm here to tell you, if you want to cut it down to the bottom line, if your goal as a nonprofit is to attract the most sophisticated directors to serve, those directors are going to look for that line of defense in your articles of incorporation. And so get ahead of that conversation and make sure that you hardwire it there. The next feature of law is statutory immunity. This is gold for North Carolina nonprofits. This particular provision, you don't need to elect into it. It is a benefit for nonprofits by default. And what it says is that if you are not compensated as a director, or you haven't engaged in some bad act on your own for which you could be liable, and assuming it doesn't involve motor vehicle injury, in general, you will not be held to a financial judgment put in place by a court vis-a-vis your service as a director of a nonprofit. This is huge. Now, a court could impose injunctive relief. Don't do this, do that. But in terms of protecting your pocketbook, the North Carolina legislature went a long way when they adopted statutory immunity. This is a powerful, powerful feature. Now, this does not mean that you would never come out of pocket in connection with a lawsuit, because a plaintiff could always add you as an individual defendant in a lawsuit, in which case you would have to hire a lawyer, and lawyers can be expensive, hire a lawyer to have the case dismissed as vis-a-vis you as the individual director. So you could have some out-of-pocket expenses in connection with pleading the affirmative defense of statutory immunity. Why do I say that? As an important fact, you must have indemnification and D&O insurance to protect you in the event that you have to plead statutory immunity. Check. So what is indemnification? This provision appears in the bylaws typically. It can be in the Articles of Incorporation. Sometimes you see it by resolution. I prefer to see it in that internal document, those bylaws that we've already talked about. And indemnification comes in lots of different flavors. Mandatory is what you're looking for. If you get to the place where you are having a dispute with the nonprofit about whether they should reimburse you for something you've had to pay in connection with your service, you really don't want anybody having discretion. So, generally mandatory, assuming you've not created the harm by your own bad act, of course. And I like an indemnification provision that provides the opportunity for the nonprofit to pay as you incur expenses in advance of the final resolution of the case. We know these lawsuits can drag on for years, so very much encourage you to look for an advance payment provision in the indemnification provision. Now, an indemnification obligation for a nonprofit is only as good as the resources of the nonprofit. If your nonprofit is new or small, or catastrophic litigation wipes out the nonprofit's resources, that indemnification provision could be meaningless unless you have directors and officers insurance to back it up. So make sure that that's part of the overall insurance protocol for the nonprofit. Okay, we're almost there, gang. 2 slides left. The first, traps for the unwary. Before you agree to join the board of directors, I want you to ask yourself and the organization at least 3 questions. The first, does my passion, my personal passion, match up with the mission of the nonprofit? If you are not on fire for the nonprofit's mission the day you show up for the first board meeting, I'm pretty sure you're not going to be on fire for the nonprofit when you're doing the hard work of the nonprofit organization in terms of raising the money, reviewing the 990s, et cetera, et cetera. So be on fire for the mission of the nonprofit before you agree to join the organization's board. Figure out how much time your service is going to take. And how much time is not just how often does the board meet, because the work of the organization often happens, largely happens, outside of the boardroom in the form of committee meetings, events, serving as an advocate, as an ambassador. So know that it's a lot more than just sitting around the table for the pre-scheduled board meetings. So figure out how much time it's going to take and at what cost. We've already talked about the personal responsibility to enthusiastically, joyfully write a check that hurts just a little bit. Just a little bit. So figure out whether that organization has a number in mind and make sure that that number, again, aligns with your capacity and, of course, your compassionate commitment. Failing to mitigate exposure to liability. This is an important consideration. Look back at the slide, one before, hopefully before you join the board, but certainly there's a chance to fix or to address any gaps in the risk management profile for the organization after you've joined the board. But make sure that you're really focused on that risk management strategy as it relates to you and the organization overall. This is really important for our lawyers and accountants and other technical people to remember. Never substitute technical compliance for your common sense. Just because you can find a rule or a law or some other reason to validate something that gives you a funny tummy feeling, always err on the side of common sense. And why do I say that? Because it relates directly to the last bullet point of underestimating reputational risk. Nonprofit organizations, by and large, rely upon voluntary contributions. If you lose the trust of your stakeholders, you will also lose access to that very important stream of revenue that sustains and amplifies the mission of your organization. So be very mindful of the expectations of your community and use your good judgment because you have it. So before I leave you, and what a joy and a privilege it has been to be part of this Greater Good series, I want to give you a few parting thoughts. 1, when you approach your nonprofit board service, start from a place of gratitude, a place where you acknowledge the important work nonprofits are doing in our community to make our city more livable, better educated, healthier, more humane. So start from that place of gratitude where you know that your talents can really fuel these organizations that are doing so much good. Create space in your busy life. I know how it is, and I know that it takes discipline. So I encourage you to really arrange your life in such a way that you have time that you can dedicate to these nonprofit organizations. And most importantly, find that sweet spot. Find that sweet spot in our community with a nonprofit where your personal passion, where your on fire for the mission for the organization, collides with an organization that is fulfilling that need in powerful and important ways in our community. Find that sweet spot. Always stay focused on charitable mission. When you are in that boardroom and you have networking opportunities and avenues to advance your career, know that all of that may be a lucky byproduct, but your number one job is to check your ego at the door and keep that shared vision and that mission for the organization front and center always in your board service. And I say this all with the full confidence that you are extraordinarily talented individuals. Use this information that you're gathering through Greater Good, and certainly the relationships that you're building with the other participants in this incredibly impactful program, and get out there and change our world. You can and you must. Thank you.